So I have an individual on here by the name of Chantel Nolf. Can you tell me which party you're representing?
Chantal Corey is my name that all the papers are under, but I got married, so my married name is.
Oh, Corey. Okay, so let me just put Nolf and then Corey so I don't confuse myself. Thank you.
Of course.
And then I have an individual here with the name of Claudia Barajas. Can you tell me which case you're on?
I'm representing PayPal.
PayPal, thank you.
Mhm.
Okay, good morning. I am Judge Osler and I'll be conducting the hearings today. You are here because you are a party to a small claims case. In Clark County Small Claims Court, the parties are required to participate in mediation before a case is set for trial. The purpose of this hearing is to assign a mediator and a date for mediation. If after mediation the case is not resolved, a trial date will be set by the court. If plaintiff fails to appear for this pretrial hearing, mediation, or trial, defendant may request that the small claim be dismissed and a default judgment be entered on any counterclaims that may have been filed. If a defendant fails to appear for this pretrial hearing, mediation, or trial, plaintiff may request that a default judgment be entered against the defendant and any counterclaims dismissed. After my introductory remarks, I will call cases to determine if both parties to the claim are present. If both parties are present, you will be placed in a breakout room with a facilitator from Community Mediation Services for the purposes of scheduling mediation. Once your mediation has been scheduled, you may hang up from this call. For all other cases, please remain in this hearing until you have been excused by the judge. Before scheduling your mediation appointment, I would like to say a few words about the benefits of resolving your case through mediation. The first benefit of mediation is that you maintain greater control over the outcome of the case in mediation than you do during a trial. At trial, you let the judge make the decision for you. Even though both sides usually feel they will win in court, in fact, one side will lose. In some cases, both sides may feel they have lost. In mediation, you're creating a win-win solution together with the other party and don't need to agree to anything that doesn't work for you. You can't lose anything by giving mediation a try. In fact, you have a lot to gain. The second benefit of mediation is that the process is much more flexible than a trial. Keep in mind the judge will have several cases to hear on your trial date and will not be able to devote an entire morning or afternoon to your case. When you go to trial, the judge will restrict the parties to discussing only those issues that relate directly to the case. At trial, the court can only award a money judgment. In the process of reaching an agreement in mediation, on the other hand, you have the opportunity to have a wider ranging discussions of things which may be important to you, such as return of property, correcting repairs, apologies, discounts, and payment plans are all things that could be included in a mediated settlement but couldn't be included in a court-ordered judgment. Another advantage is the mediator will help you write out any agreement you may reach. You'll have the opportunity to read it over and think about it before being asked to sign it, so you'll know exactly what your rights and obligations are under the agreement. If you are here because you owe someone money, you should be aware the inability to pay a debt is not a legal defense to the debt itself. Many people come to court agreeing they owe the debt, but indicating they are unable to pay the debt. In mediation, it may be possible, if both sides agree, to arrange monthly payments. Normally, a judge will not do this for you. Another benefit of mediation is, if you reach an agreement, no judgment is entered against you. Sometimes judgments can adversely affect a person's credit rating, and some lending agencies might be reluctant to lend money to people who have judgments against them. As long as you are making payments according to the terms of the agreement, no judgment will be entered against you. If you are the person who is to receive money or other satisfaction under the agreement, and the person who owes the money doesn't pay or perform according to the agreement, you don't have to file a new court case. You can file an affidavit of noncompliance. The judge will review the affidavit as well as the agreement in the court file. If the judge determines the parties had reached an agreement and the plaintiff attests the defendant has not complied with the agreement, the judge will sign a judgment for the amount originally asked for in the claim, unless the agreement specified a different amount. From that point on, the person holding the judgment can collect it, less any money already paid under the agreement, using any of the methods provided for under Washington law. If privacy and confidentiality are important to you, please keep in mind the court proceedings and judgments take place in a public courtroom in front of other people and are a matter of public record. Mediations are private conversations and may result in a settlement out of court, which helps protect both reputation and credit rating. Again, you are required to mediate your case before it can be set for trial, and I urge you to mediate in good faith. You should be willing to share important information, listen to the other person with an open mind, consider what needs to be done to resolve the dispute, and be willing and able to keep any agreements you make. You have nothing to lose by mediating your case. In the event you are not able to reach an acceptable agreement in mediation, your case will be set for trial before a judge, and you will still have your day in court. We have found that people who have unsuccessfully attempted to mediate their small claims cases are better prepared for trial. Okay, and I just had someone enter the courtroom. Can you just give me your name? Sir, are you on my docket today?
Last name is Lestry.
Okay, Steve Lestry? Okay, perfect. Thank you. All right, so there are a few of you, I think that I have both sides present, and one of those is Chantel Okori and Jamie Kenny. I see you're both present. So if you two could please unmute yourself, and I'm going to put you in a breakout room. I'll just start with Miss Michelle because I see her there on the top of my screen. So Jamie Kenny, Michelle, and Chantel. And to unmute yourself, Chantel, you might have to scroll your cursor over your picture. Hopefully you're still there. Can you hear us still? Miss Nof or Corey? I'm going to try to move you in there, and hopefully she'll unmute while you guys are in that breakout room. So I'll move Michelle, Jamie, and Chantel Corey in there. I also see that I have Mr. Rhine and a representative from PayPal, so I'm going to move you folks into breakout room number 2. If you get an invitation, please just accept it. And Mr. Ryan, there we go. And then Miss Nof Okori, I still have you in my room with me. Okay, Philip, I'm not seeing any of your folks here today yet. Or maybe I lied. I don't have a matchup. Okay, let me go through your cases then.
Alrighty, thank you.
Michelle, I can see that she's still here.
Yeah, I don't think she heard.
And I've been trying to get her attention. Here, let me send her a chat message, and then Philip, I'll get to you here in just a
All right,
second.
thank you.
Let's see if she can at least see my chat message to her. Okay, I sent her a chat message, so we'll see if
See if magic can.
see if something happens. Chantel, no, or Corey, can you hear me? You risk your case getting dismissed unless you're able to unmute yourself. I don't know what happened to you. I can see that you're present. Did you find a date for at least the other party, Michelle?
I haven't yet. Do you want me to just schedule and then I'll contact Chantel a different time?
Yeah, we might need to do it that way because I know she's here, so I'd feel bad not trying to set it up. But I don't want to keep the other party waiting forever.
I'll just schedule and then I'll contact Chantel at a different time.
Sounds good. Okay, Phil, now we're ready for you.
All right, thank you.
So the top case I have is United Finances versus Billymon. And then the next one I have is United Finance versus Janet Billymon. So I wasn't sure if those two defendants were related and should have been filed under one claim. Is it the same debt or is it two just completely separate things?
No, they're two completely separate loans.
Okay. All right. So I did see that there was proper service on Billymon, and there did appear to be, he does not appear to be in the military. So let me just make sure. This is a little bit different because we have hearing notices in here that were sent out. It's hard to tell who they were sent out to, but you received a hearing notice, is that correct?
I did, yes. Yes.
And you served the dates on there, October 20. Oh, that's why, because it says October. Oh, no, today is the 26th. Okay, I went 1 too far days on my calendar there. All right. So we will go ahead and sign a default judgment for the amount requested, which is, do you need that for me?
I have it.
Okay, $3,399.38.
Yes, ma'am.
What's the filing fee nowadays? 50, is that right?
$50, yes.
And then proof of service, is there $50 for service, it looks like as well, is that correct?
That is correct. And I'd also requested 9% post-judgment interest.
Whatever's on the paperwork, I think, we'll put 9, that's fine. It is on there, okay. All right, and Mr. Powers, we just don't have a lot of folks that are together here this morning.
Yeah, Your Honor, I just sent the two folks I was sent in back. They have a matter they need to address with you. Of one being one of the I'm gonna say it's the defendant being a paralegal. So we brought them back in.
Okay, all right. I'll have to close out that breakout room,
Okay.
which I will do in just a moment after
Great,
Michelle's
thank you.
done the other ones. Okay, so default judgment centered on Billymon. And then I have a Janet Billymon, which is case 20S000388. And there did appear to be proof of service, proper proof of service in this file, and a military status. So she's not in the military. And the amount requested is the $27.50.59, which I will grant, plus the $50 filing fee. And this also looks like it's $50 service costs. And then United Finance versus Ezra Dickerson is case number 20S000391. And I did have an opportunity to review prior to court. There does appear to be proper service in the file. She doesn't appear to be in the military. And I show the amount requested is $5,000 for a loan that remains unpaid, $50 filing fee, and this one says $75 service costs.
That is correct.
Okay. All right, then I got Miss Chantel Nofakori back. Were you able to schedule Michelle with them?
We did.
Okay, and Ms. O'Corey, you are good to hang up at this time then.
Awesome. Thank you.
You're welcome. And I'm closing the breakout room and trying to bring back Ms. Barajas and Mr. Rhine. So it's my understanding, Ms. Barajas, that you're a paralegal, excuse me.
That's correct, Your Honor.
And so I can't schedule the mediation just based on having a representative here, but I will tell you that the rules of civil procedure indicate that, let me find the exact language here. A corporation plaintiff may not be represented by an attorney or a legal paraprofessional except as set forth in 1240.025 or 1240.080.
Does that include if the paralegal is employed by PayPal? Because I'm an employee of PayPal.
As a paralegal?
That is correct.
Okay. I'm looking it up because it doesn't come up that often, so.
I've appeared in Washington courts before for small claims, and I was able to represent PayPal, so this is news to me. So I apologize for wasting the time.
Okay, and then 1240.080. Okay, so it says no attorney at law, legal paraprofessional, nor any person other than the plaintiff and defendant shall appear or participate with the prosecution or defense of litigation in the small claims department without the consent of the judicial officer hearing the case. A corporation may not be represented by an attorney at law or legal paraprofessional except as set forth in 1240.025. In the small claims department, it shall not be necessary to summon witnesses, but the plaintiff and defendant in any case. Okay, that's okay. Let me look at 1240.025. They keep citing me to different statutes. Okay, this is the one I just read. So there's no other representative from PayPal that can appear on behalf of PayPal?
And not in such short notice right now, but we can reschedule, and I can have somebody else appear for us.
All right, so what I'm going to do is allow you to go ahead and schedule the mediation today, and then if you can find a representative that would be appropriate to represent the corporation, they can appear at that mediation.
Okay.
I'm going to move you guys back. Yes, sir. Mr.
Your Honor, I have a question. The way PayPal's been handling themselves, avoiding me, and what if they send another paralegal or an attorney to the mediation? What do I
We're
do?
told we
that-
can't, we won't.
Yeah, she's already been told that, so there'll have to be another representative. So I'm
Okay.
going to move you guys into breakout room number 3, and I'll let you get that scheduled, and then you can hang out from there. And Michelle, don't go anywhere. You might have got another invite, but you don't need to go there. I do have somebody in my waiting room, so let me see, make sure that's not